Hey guys, this is Kendall Bonner with Remax Capital Realty on this lovely April day in 2016. Today's class is Advanced Contracts, and we're going to be using a quiz as a part of this class to test your current knowledge and hopefully to correct some misconceptions if possible, if any, and to create some new techniques and strategies and best practices for you going forward in the future. All right. So thank you so much, and I'm so glad to be with you today. So I always like to start my classes with a thought for the day, and today's thought for the day is permanent changes in our actions have to be reinforced by permanent changes in our thinking. Okay, so this might be a shock to you, but you have been given the limited power to practice law in the state of Florida as it relates to writing real estate contracts. You're filling in the blanks. You are creating terms that obligate your customer to perform, and also giving them rights to sue the other party when they breach or when they don't perform. So it's really, really important that you take this practice seriously and that you really hone your skills and really learn what's important about writing contracts. Now, per the Florida Association of Realtors.org, the contract contains terms negotiated by the parties. It defines each party's rights and obligations. Therefore, the licensee who prepares the contract must be thoroughly familiar with its terms and with the expressed intent of the parties. The licensee is liable for his or her mistakes. If the licensee is not sure that a clause expresses the intent of the parties, the licensee should suggest legal counsel be retained to draft that clause. So what does that mean to you? Basically, what we're trying to say here is, keep it simple, be very strategic and specific about what you're trying to do, and make sure that it is the will and the intent of your customer. Please don't go and make up stuff for them and try to anticipate what they want and need. Just have a conversation with them. Let them know what I like to call the 3 O's: their obligations, their opportunities, and their options. And let me define those for you. Obligations, those are the shalls. Like when you see in the contract, buyer shall or seller shall, those are obligations, meaning if they don't do it, it's literally a breach of contract. So it's really important that your customer know what they have to do and what they're not supposed to do as a part of the terms of the contract. Their opportunities, this is where maybe the customer has some choices, right, and some leverage to do something or not do something, or to enforce a clause or not enforce a clause, and use that to renegotiate or to continue negotiations. But really, it's where you find leverage. And then options are situations where they have, again, choices, but there's no leverage. It's just, hey, it could go this way or that way. It's really up to you, Mr. or Mrs. Buyer or Mr. or Mrs. Seller. These are your options. These are your choices, okay? So Bill and I worked really hard together on creating this class and this content, and Bill and I don't always agree, but we want you to, and that's all lawyers. Most lawyers don't always agree. That's why we have opposing sides, and we have judges and juries and things like that. But we're trying to give you some rules to function by and to perform with. But understand there's always exceptions to the rules. And the tricky part is you should not be applying the exceptions to the rules without legal counsel or legal advice, okay? So when in doubt, ask a lawyer. Get a lawyer involved, okay? That's the best thing that you can do for your customer. Now, in order to frame our discussion today, I found that a questionnaire is an effective way to review what we know and sometimes what we don't know. So this is a safe place. No one knows if you got the answers right or wrong. But just, participate. It's in your best interest because it'll help you recognize what you really know and what you don't know. Okay? So let's skip through this part because we're going to go through it together. So let me ask you, how many purchase contracts are in circulation for use in our Florida real estate market? 2, 3, 4, or 5? So sorry I hit the button too quick, but yes, the answer is 5. We have 5 different contracts for use, and you can see the list here. We have the FAR bar as is, the FAR bar 3, actually this needs to be updated. It's the FAR bar 4, the crispy 14, commercial contracts, and vacant land. Okay, so those are our 5 contracts. And let me ask you, how many have you read in detail, if any? Most agents haven't really read them, and even if they have, don't really understand them. So the goal of this contract series is to help you understand each of those contracts and how they're different, and how you or your customer may strategically want to use one versus another. It's important that you understand the differences between them, and also why you're using whichever contract you are using. Is it because someone told you to use it, or because it's the best contract for your customer? Next, which of the following makes a valid Florida real estate contract? So the first answer is 1, it must be in writing. 2, it must be signed by one party to it. 3, witnesses are required. And number 4, it's 1 and 2. Well, the answer is 1. It must be in writing because of the statute of frauds. The statute of frauds requires that contracts for real property in Florida must be in writing and no witnesses are required. Contracts should be signed by the party against whom enforcement is sought. So basically, both sides need to sign it for it to be enforceable. Okay? Which of the following are material terms to Florida real estate contracts? Number 1, the sales price, the escrow money deposit, the closing date, and legal description. Or number 2, sales price, closing date, property description, and the parties. Or number 3, the sales price, escrow money deposit, closing date, legal description, and the parties. Or number 4, none of the above. Which one do you think? The answer is number 2, sales price plus the closing date plus the property description plus the parties. There must be a meeting of the minds as to the material terms, and material terms are who the parties are, so who's involved, the description of the property, the price that they're paying, and the closing date. Generally, courts will not look beyond the 4 corners of the contract to determine intent as it relates to material terms. Okay? So next, which of the following should sign a real estate contract? Number 1, buyers and the sellers and the real estate agents. Number 2, witnesses. Number 3, any and all buyers, sellers, and adults over 18 living with the seller. And then number 4, all of the above. The answer is number 3. Seller's name should be written on the contract as they are written on the prior deed. You can often find this in the public records. Buyer's name should be written in a manner consistent with how they will take title. So example, as husband and wife, as joint tenants, etc. Now, when you're writing out those buyers' names in the manner in which they plan to take title, that is a legal question. So that's not something that you should really be advising your customers on how to do that, but you may want to ask them if they plan to take it as husband and wife or as joint tenants, etc., etc. If not, the title company will ask, or perhaps you can involve your title company right away and ask them for suggestions. So that way we make sure that the contract is written correctly and you don't have to do a bunch of addenda to correct it. Also with that, make sure you include their actual legal name, including middle initials. Some people use middle names. Some people are, junior, senior, the third, etc. Those are all important factors that sometimes in rushing to write the contract, we forget to ask, and can cause you to have to write, multiple addenda later in the game. Now, also, you want to name all the owners, including any spouse, especially if it's a marital home, and or any adult over the 18 who occupies the property as their homestead. This is a did you know? As you can see on your notes here, unlawful detainer actions. If you invite someone to quote unquote visit and they take up quote unquote permanent residence in your home, In Florida, you have to initiate a type of eviction proceeding to remove them, and this is called an unlawful detainer action. So we want to, of course, avoid this, and the only way to enforce a person to agree to a contract to sell is to make sure they sign the listing agreement and the contract. Okay, so that's a did you know for you. Number 5, where is the best place to collect the seller's name? Is it 1, the MLS, 2, Realist and or IMAP, 3, the prior deed, and 4, title commitment? The answer is 3, the prior deed. The best place to get it is the prior deed or the prior's owner policy, title policy, not the MLS. There's often mistakes or problems with the MLS, IMAP, and Realist, and if that is where these things are copied from, i.e., because they come from the tax bill, they may be missing certain information, including additional sellers or life estate information or trust information. So it's really important that you go back to the actual deed, confirm all the last owners, and making sure they are the ones that sign your contracts and or your listing agreements. Here's a top tip. Please, 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 please do not use owner of record. That is not good. And there's a lot of reasons why that's not appropriate. One of them being, how do you know who's signing it if you don't have a title or a name of the seller? Number 1. And number 2, often how many times can we actually read people's signatures? Some people scribble, right, when they write their names. So it's really important that sometimes that first line on page 1 is the only place we have anywhere on who the seller is and who's actually signing the contract. So it's really important that we go that extra step and find the actual owner's names and place them at least on page 1 of the FAR bar contracts when you use them. Number 6. If the location of the property cannot be determined by the description, the contract is not legally enforceable. Is that true or false? What do you think? It's true. If the legal description is essential to the contract, if the location of the property cannot be determined by the description in the contract, then the contract may not be legally enforceable. Again, copy this from the prior deed or the prior owner's title policy. Okay, so I can give you a story that was not good for a personal situation for one of my customers. The homeowner had purchased a lot, or actually it's 2 lots, and built a home. Well, then they ended up acquiring a 3rd lot next to it and expanding their home. So the driveway reached across the 3rd lot. Well, they now had a couple of different mortgages. They had a first and second mortgage on the first 2 lots, and then they had a third or individual mortgage on the 3rd lot. Problem was, with the legal description, there was a sliver of land about 2 inches wide and several feet long across down the middle between the 2 lots that was not included in the legal description. So it was missing, several inches between lots 2 and 3. That was actually a problem. And we, unfortunately, the bank couldn't foreclose. Like, it was really a big deal. It made it difficult to foreclose. It also made it difficult to sell the property and to write title insurance because that little sliver was still owned by, 3 deeds back, or at least 1 or 2 deeds back from another owner. Number 7, true or false? All personal property that is physically attached to the real property shall remain and convey with the property regardless of the seller's intention, just because it is attached. True or false? The answer is false. It's a little tricky. A fixture may be any item physically attached to the real property, and the homeowner must intend for it to be a permanent part of the property. So if it can be removed without much difficulty, it may not be a fixture. So the best practice is do not assume that it is a fixture. If they want it, i.e. your customer, the buyer, wants it, specifically ask for it. Write it in the contract to remove it or to leave it behind. also for your customers when they're sellers. I often tell my customers when I'm listing at the listing presentation, do you want the ceiling fans? Do you want to take, any fixtures in the home? Is there a chandelier that's particularly important to you? If so, remove it before we even take photos of the listing. And if they feel like it's particularly important to leave it up for the purposes of marketing, then I make sure that we put it in the MLS that it is not conveying, and also make sure it is in the contract that it is not conveying. Oftentimes, I remind my customers, buyers' mindset is what I see is what I get. So if they don't see it, then it's not a big deal. But if they see it and they don't get it, oftentimes that's where you have problems at the final walkthroughs. So regardless of the customer's intent. So it's really important to have that conversation on the front end of a listing as well as the front end of writing offers when you're representing a buyer. Also, I remind people, top tip number 2, if it's not in writing, it doesn't exist. So don't just think it, ink it. You guys have heard me say that before. So make sure that if they want it, you put it in writing. Number 8, true or false? Escrow deposits are always required and must be delivered in the form of a cashier's check or money order. Is that true or false? It is false. A real estate contract is legally enforceable without EMD or without escrow money deposit or escrow, period. Escrow money escrow money represents a pre-negotiated liquidated damages for breach of contract. So just so you know, EMD can be a boat, a goat, a car, a diamond. It could be money. It can be anything that the parties agree on that has some sort of value that both parties agree that in the case that a buyer breaches, the seller gets to keep it and in exchange is not going to sue the buyer for additional damages. So it's really important when you do escrow money deposit that one, of course, you're looking to see if the parties are serious, but you're also pre-negotiating if there is a breach and the seller is harmed, that the seller is going to accept that escrow money deposit in exchange for not suing the buyer. Usually that's how that's supposed to work, okay? Number 9. All parties are allowed 2 business days to review all offers and counteroffers. Is that true or false? I hope you guys know this one. It is false. Deadlines are negotiable at the time of offer and counteroffer. So an associate should insert a date of expiration to avoid any uncertainty as to the time limit for acceptance, right? So that first date that the buyer offers the seller to accept the terms, there should be a date. I don't recommend, leaving that blank at all. And then also, and this is a strict deadline in all the contracts, the offer is withdrawn if not accepted prior to that expiration of the deadline. So then at that point, any time that the seller, let's say the seller executes after that deadline, it is now a counteroffer and not an acceptance. And now the buyer has to sign off again, saying that the offer is still, that they're still willing to work on that particular property. So top tip number 3, no blanks. Do not leave any blanks in your contracts. If you want to use the recommended time frame that's pre-written in the contract, just write that in. Don't leave it blank. If it doesn't apply, put NA for not applicable. I really, if it needs to be 0, put 0. It's really important not to leave blanks because you never know when the other party reviews it and executes it, how do you know they didn't plug something in that your customer did not agree to? And oftentimes people don't always initial their changes that they make or bring it to your attention. So in order to avoid that, it's best that you mark it up completely. That way, if they try to change anything, it will be more noticeable than had you not done anything like that. Number 10, if the last party to sign and initial does not timely deliver the accepted terms, the offer is automatically withdrawn. or is deemed withdrawn. True or false? The answer is true. See paragraph 3 of the FAR/BAR contracts and paragraph 22 of the CRISP contract. Delivery is required for all residential sales contracts. And that actually is a change. That was a mistake they had made in prior contracts. They'd only said the last party to sign or execute. But they've since corrected that, and now delivery is required. So, and remember that delivering via email to the agent of a customer is delivery to the customer. So even if the listing agent or the buyer's agent is on vacation, they got the email, but they didn't notify the customer, it doesn't matter. The customer is still now noticed because their agent received notice. So really important that you, when you get those documents back from your customer, you forward to them as quickly as possible. Number 11, true or false? FAR/BAR as is contract. If this seller never responds to a buyer's repair request and the buyer fails to cancel the contract before the end of the inspection period, the buyer is still required to move forward with the transaction. True or false? The answer to that is sadly and unfortunately true. See paragraph 12 of the as-is contract and paragraph 18. Unless the buyer exercises the right to terminate granted herein, buyer accepts the physical condition of the property and any violation of governmental, building, environmental, and safety codes, restrictions, or requirements, but subject to the seller's continuing as-is maintenance requirement, and the buyer shall be responsible for any and all repairs and improvements required by buyer's lender. That is a big deal, especially that last sentence. This is especially a problem for any financed buyer without an addendum protecting them, because you've now obligated the buyer to pay for the repairs of any appraisal inspection requirements. That last line, the buyer shall be responsible for any and all repairs and improvements required by buyer's lender. That comes out of paragraph 12 for those of you that don't know that. So please make sure you go read paragraph 12 of the FAR/BAR as is contract, okay? If you use the appropriate addenda in the as is contract, you can protect your customer from that last line, and you will need to watch my next contracts class on the FAR/BAR as is to learn how to do that appropriately and safely, so that you don't obligate your customer to have to do something they cannot afford to do and then put them in breach of contract. Okay, and then see also paragraph 18X on page 10 of, it's either 10 or 11 on the FAR/BAR as is 4, where the buyer waives all claims. So that's another change to the FAR/BAR as is as compared to the FAR/BAR 4. Number 12, true or false? All warranted items in the FAR/BAR 4 and the CRISP 14 contract must be in good working condition, and the FAR/BAR as is contract must be in fair working condition. And again, forgive the typos for 3 and 13. This contract class was built just before the CFPB changes in October. So I will be sure when I re-record this to update that. So don't let that confuse you. The answer to this is false. The as-is contract offers no warranties at all, only a property maintenance requirement in paragraph 11. Now, which was existing at the time of the effective date. So basically what that means is if it was broke when you went under contract, it can stay broke when you close. If it was working at the time you went under contract, it's supposed to be working when you close, even in an as-is contract. So that's also really important distinction to remember. Some people think that just because it's as-is means that even if stuff breaks, the seller's not responsible to fix it, and that is not correct. If it was working at the time you went under contract, under the FAR/BAR as-is contract, it has to be working when you close. Now, under the other contracts, FAR/BAR 4 and CRISP 14, they do require working condition only, not good, bad, or noisy. So see paragraph 12B2 of the FAR/BAR 4. It doesn't warranty anything, but it does call for general repair items. And then under the Crispy 14, it offers a warranty for certain items in working condition only. No contract allows for the repair of cosmetic conditions. So that's really important too. So painting, fixing the cleaning the carpet, washing the walls, that is not, those are cosmetic things, and those would not be considered items for repair under any contract. Number 13, title company is responsible for searching or researching and notifying the buyer of any and all permit issues. Now, you guys ought to know this one. That is false. The buyer may, at buyer's expense, may search for permit issues. There's no specific permit inspection in the FAR bar contract, or the FAR bar as is, but the parties, meaning the seller, is required to cooperate with the buyer to identify any open permits and assist in the buyer getting those closed out, or the buyer can just waive all of that. There is a disclosure requirement of all sellers that whether they are aware or unaware of any open permits or permit issues. So agents, remember, when you have your seller sign these contracts, make sure you and the seller are looking in the public records to confirm that there are no open permits, okay? So, and the other reason why you don't want to wait for the title company is we all know by the time the title company can get to this issue, it's often too late. If you're under the FAR bar 4 or the Crispy 14, the buyer has a limited amount of time to review these areas and under the FAR bar as is, to look at these items and issues and cancel the contract. So you'll lose that right for permit issues if you don't do it timely. Permit deficiencies are due at the end of the inspection periods under basically all of the contracts. So you want to make sure that you get to that information as quickly in the front end of the process as possible. So number 14. This is a fill in the blank. And I want you guys to think about this in terms of the three main contracts that we use in real estate, and that's the FAR bar as is, the FAR bar 4, and the Crispy 14. So how many default days does the buyer have to notice the seller of any repair requests? The FAR bar as is, NA, the seller has no obligation to make repairs. So there's no days for the buyer to notice the seller of any repair requests, because technically they're not supposed to ask for any. Under the FAR bar 4, they have 15 calendar days under the default unless you negotiate something different. Basically, the end of the inspection period deadline is when the buyer has to notify the seller in writing of any repair request. Under the Crispy 14, they have 5 business days after the inspection deadline ends. Speaking of business days and calendar days, this should be a hint to you. The FAR bar contracts, both the FAR bar as is and the FAR bar 3, or FAR bar 4, all operate under a calendar day timeline. And I recommend starting the delivery date as day 0, and day 1 is the following day. Under the Crispy 14, you get business days. So that's why the timelines might seem shorter, but it's because they're only counting business days. You get a bit more time, okay? Number 15, how many default days does the seller have to respond to the buyer's repair request? So the first one for the FAR bar as is should be easy for you. NA, seller has no obligation to respond. Under the FAR bar 4, they have 10 calendar days from the receipt of the request. Okay, these are your default days again, unless you negotiate something different. The Crispy 14 is 5 business days from receipt of the request. Number 16. We're almost done, guys. 2 more. How many default days does the buyer have to notice the seller of any WDO, which is wood destroying organism, repair request? All right, same thing, right? FAR bar as is NA. The seller has no obligations to make repairs. Under FAR bar 4, they have 15 calendar days, i.e., again, the inspection period deadline. And the FAR bar 14 is 5 business days from the date of the WDO inspection. So that's a little bit different. So if the WDO inspection was done within 2 days of going under contract, then they have 5 business days from that date. If it was done at the end of the inspection period, they have 5 days from that date, okay, to notice the seller in writing of any repair request. Again, if you operate outside these deadlines, the seller can, the buyer is deemed to have waived these requests. Okay, so really important that you do these things within your inspection deadlines. Last question, number 17. When must the seller deliver the prior owner's title policy to the buyer? Do you guys know that one? Number 1, the FAR bar as is, they have 5 calendar days from the effective date. Under the FAR bar 4, again, they have 5 calendar days from the effective date. Notice that is not 5 days from closing. That's 5 calendar days from the effective date. So if the seller is trying to get a discount on the new policy, oftentimes, they are required to give the prior owner's title policy to the title company. When they do that, they should also be sending that out to the buyer for review as well. And then under the CRISP 14, it's 5 business days from the effective date. So only the owner's title policy should be provided, or the owner's title policy should be provided. I apologize. If the seller can't locate it, then they should research their prior deed, listing agents, and request it from the prior title company. The only exception to that rule is perhaps cash deals. It may not be a necessity for the customer at that point. So, best practice tips. 1, we talked about these already. Do not use owner of record, right? Do not use owner of record. Do not use owner of record. Please go find the prior owners and submit their names into the contract so you know who's signing and who's required to sign. Number 2, if it's not in writing, also about owner of record, that also lends itself to fraud and malpractice because it may be difficult and impossible to legally enforce the contract without knowing who the owner is. So moreover, deeds do not have to be recorded for them to be legal and binding. So then the owner of record would not in fact be on record. Okay? So if you didn't catch that, because you don't have to always record deeds, the owner of record may not in fact be on record. Okay. Number 2, if it's not in writing, it doesn't exist. Repairs, agreements, changes to the contract should all be in writing and signed and or initialed by all parties. What if 2 years down the line something happens? Parties remember whatever is in their best interest, not necessarily the facts of the situation. So make sure that you put it in writing because otherwise people will not remember. And next is no blanks. Fill in the defaults with, fill in the blanks with NA or O or 0 if it's necessary, or use the default timelines if that's what you so choose. And last, date all initials. It makes it easier to determine the last signature initial for an effective date and final execution. Sometimes, a seller will counter and send it back to the buyer, and the buyer is initialing and agreeing to the changes the seller made, but they don't date them. So now what date do we have on the document? Usually it's going to be the delivery date is the effective date, but at least that can initialing the the changes and putting dates next to those initials, we know when the last time the party actually initialed. And so then we're looking for the delivery date after that. So it will help prevent some confusion, and it makes the chronological order easier to determine. So thank you so much for listening to my class today. Your feedback is always appreciated. So thank you. And let me know if you have any questions. I'm happy to answer them for you. Have a great one.